but we're doing an executive session because today. You're on right now? Okay. Okay, we'll see you when you get here. Okay, we're going to call this study session to order. We have one of our board members via technology, Zoom, or one of those things, and Maria Garcia will be here momentarily, but we're going to just start, if that's all right with everybody. So our first item of discussion is our college legal services model, and it's going to be presented by Jeff Sylvan, Seth, just Jeff. Okay, thank you, Jeff.
All right, thank you, everyone. So what I thought I would do is provide a little bit of an overview about how legal services work at Pima. So a little bit of the history, the rules, the kind of standards that we follow, some specific examples about how it works, and then see if you have any questions or particular issues that you would like to have addressed. I did ask Lisa Ann Smith to join us. I'm not sure whether she will make it here in time. I can talk about how legal services that get appointed through the Arizona School Risk Retention Trust work and how we work with outside counsel. I thought it would be also helpful perhaps for you to hear from someone who has done that role for many years, but I can probably cover the basic topic in case she doesn't make it. She had another commitment and we weren't entirely sure about the timing. Okay. So for a long time, meaning 20 years or more, Pima College relied on outside law firms to provide legal services. There were no in-house legal services. The general counsel position was created in 2012. I started at Pima in 2013. So for 20 years or more before that, legal services were handled all external to the college. There was an internal college person who coordinated that, but essentially the college relied on a law firm to provide the bulk of legal services, and then that firm would either help the college find other attorneys when there was a need for more specialized services that that particular firm couldn't handle, or in situations where if that firm had a conflict of interest for some reason, then they would find another firm to provide the services. And how I know about that is actually from 1995 to 2000. I worked at the firm that played that role for the college. So I did that for a while. And that's how things kind of worked. So then I think it was in 2012, the college decided that they should have a full-time lawyer on staff in the college, which is pretty common at larger institutions. And so the college created the general counsel position. I was hired in 2013. Well, no one had ever done this at Pima before, so the first thing that we had to figure out is, well, how are we going to do this? What does it look like? And so what I did is looked at what I thought were some comparable institutions and models that we could use at Pima. So if you look at the board policy on legal services at Maricopa Community College, it looks remarkably like the policy at Pima, or actually it's the other way around. The Pima policy looks remarkably like what they have at Maricopa. I also did research with the Arizona University system, both with the Board of Regents and the individual universities, Tucson Unified School District, and there's a national organization for higher education lawyers. And so we kind of looked at all those and came up with the model that we have at Pima, which is all the models that I just mentioned are pretty consistent with each other, and that's how we got to our current model. A couple things to be aware of for applicable standards. So The practice of law is regulated in Arizona. The Arizona Supreme Court sets rules, standards that attorneys are supposed to follow. And then, of course, the college now has its own board policy that talks about the relationship between legal counsel and the college, and it also refers to those ethical rules. The reason that I thought it would be helpful to mention them is because there's a couple rules in particular that really govern sort of how legal services work at Pima College. So one is there's an ethical rule that defines who is the client and what is the role of the client versus the role of the attorney. And in just very general terms, the client decides the purpose of the legal representation, what's the objective trying to be achieved, what's the goal. And the job of the lawyer is to advise the client about, well, there might be some rules that apply, help them make an informed decision, make sure they're kind of thinking through all the applicable factors, some of which might be purely legal and some of them are more practical. So for example, a lawyer might also advise a client about, well, you might want to be careful about that because if there were publicity on that topic, that could look bad for the individual or the institution. So there's sort of an advising function that goes beyond just strictly legal matters. Well, how does that work when the client is an organization like Pima? Because obviously it can only act through individuals. So in that situation, the lawyer takes direction from whoever is the authorized decision maker for that particular topic. So for example, sometimes it might be the board. Other times it might be particular individuals at the college who've been delegated certain authority. So for example, let's say there's a concern about student conduct and there might be legal implications of that. So in that situation, legal counsel's office might work with Irene Robles Lopez or Diane Deskin or one of the people who works in the student code of conduct area. Or perhaps there's an issue about an accommodation. Well, then we might be working with someone like Ken Hosto, who's the director of the accessibility and disability resources. So depending on what the issue is, there's someone at Pima who's responsible to make that decision. They decide what the goal is, and the job of the attorney is to help them try and make the best informed decision. What's important about that is, remember, the lawyer's not the decision maker. The client or the client representative is the decision maker. The role of the lawyer is to help the client make an informed decision, but it's the client who makes the decision. Another important implication of the rules that lawyers have to follow about when a client is an organization is if the lawyer is working with an authorized representative of the organization and the lawyer thinks that that person is doing something either outside of the scope of their authority, or maybe they're doing something that the lawyer thinks, well, that's not consistent with the applicable legal standards, then it's the lawyer's job to raise that with the individual. And if they don't change their course of action, if the lawyer's really confident that that's not a proper course of action, then the lawyer's obligation is to elevate it to the next higher decision maker and to keep doing that as long as necessary to either get the conduct to change or to be at the highest level of decision maker at the organization. So for example, let's say Seth or I or any other lawyer working for the college were working with a director or another administrator at the college, and they were going to do something that the lawyer thought, well, that's not permissible under Arizona state law. It can't get the person to change their course of action. They would go to, then we would be obligated to go to the administrator above that person to raise the issue. Hey, we think there's a concern here. Here's what it is. You need to know about this. If that person didn't take corrective action, we would keep going. So might end up in the chancellor's office. Chancellor, we think there's a problem. Here's what's going on. If the chancellor didn't do anything about it, then it would be go to the board. And that's one reason why in the board policy 6.01 that governs the relationship between college legal counsel and the college, it basically gives legal counsel a direct line to the board for that exact reason, that if the lawyer thinks that someone at the college is doing something inappropriate and they can't voluntarily get that changed, it's their responsibility to keep going until they get to a decision maker who takes appropriate action, or all the way to the board if necessary. So what is the role of general counsel's office? So general counsel's office provides two types of services. One is sort of that counselor advisor service we talked about before. So that might be just helping someone to make sure they've really thought through their decision. Well, what if this were to happen? What if that were to happen? What resources did you look at to decide how to make that decision? And just kind of help someone walk through a good decision-making process so that they make a good decision, and then, of course, pointing out if there might be applicable rules. There might be a state law, a federal regulation, an accreditation standard. There's some standard that the college has to meet. There's that role. And then the other role that legal counsel's office has is advocate. So, for example, we might be working with someone in the college, but then we're going to advocate and explain and hopefully persuade that the college's position is correct with an outside party. So that might be maybe we're negotiating an agreement with the city of Tucson or a vendor or some other organization. Or maybe someone has filed a complaint of some type against the college, and we are representing the college's interests in front of the agency or whoever the decision maker outside of the college. So in very general terms, those are the two roles that legal counsel plays, right? So advisor, counselor on the one hand, sometimes advocate. When I started at Pima, it was just me. Now we have a second attorney as part of the office, and then the areas under the supervision of the general counsel's office has grown since 2013. So areas that are now a part of the legal department, if you will, are internal audit. And one of the things I think that might be, two things that are maybe helpful to keep in mind. So one is, I label them independent support services, and what I mean by that is these are functions at the college. They're not part of the front-facing business operations. These are all services that support other operations of the college, but they don't provide the direct service to the students or not to the employees of the college like HR does. And one reason it's structured this way is all of these areas both provide assistance, consulting, and support services to other areas of the college. They also have a function, though, to identify if there's a problem that needs to be addressed. And so one reason they're all under the legal department umbrella is if there's an issue with another department, they're not part of the department where they're raising the concern. They have a separate reporting line, which again potentially goes all the way to the board if necessary to address an issue. Right, so if internal audit is part of an operational unit of the college, it's harder for them to be critical of the other people in the unit because they're all reporting to the same supervisor, potentially. So we don't have that at Pima. Internal audit's part of the legal department. Another function that's part of the legal department at this point is enterprise risk management. That covers sort of a range of services. So it's insurance coverage. What kind of insurance coverage should the college have? Getting the best coverage at the best price for the college. Claims management, when there's an injury or an accident or something at the college, how do we manage that, both to control what the consequences are and then figure out, well, in the future, what do we need to change to perhaps reduce the risk of that happening or the severity if something happens. There's now a compliance function that's part of enterprise risk management, so we're going to have a college-wide compliance system to make sure that there are a lot of units at the college that have compliance obligations. They all are primarily responsible, right? So financial aid, for example, has a lot of compliance obligations. It's heavily regulated by federal law. Facilities has compliance obligations. They have certain responsibilities to make sure that the workplace is safe. So there's a lot of units at the college that have a compliance responsibility. What we wanted to have was a centralized place to make sure that they're all kind of following good practices, have appropriate training in place, and sort of, again, an independent set of eyes to make sure that units are keeping up with their compliance obligations. So enterprise risk management doesn't take over those responsibilities from a unit, it's to support and provide additional oversight. Title IX is also centralized in enterprise risk management now. So Title IX is the federal law that prohibits discrimination, unequal access to educational opportunities in higher education based on gender. Because of a change in the regulations, it applies both to employees and students. In the past, it was very much a student-focused law, but now it's employees and students. And so one way to help make sure we're having consistent enforcement of those rules and a consistent process is to centralize them. So that's been done under enterprise risk management. The third area, I guess the other thing I should mention is none of these units are large, right? We have one internal auditor, we have one enterprise risk manager. We are going to add some staffing in that area to cover these functions, but also just so you have an idea, there's a lot of work going on here by a fairly small number of people. The Office of Dispute Resolution typically has 2 investigators. I think you have some familiarity with that. Their job is to serve as a catch-all. So if someone has a problem, a complaint, they don't know where to go, they can always go to ODR. ODR will match them up with the correct process. And for certain kinds of complaints, ODR is the required fact finder. So for example, a discrimination, harassment, or retaliation complaint, ODR is going to do independent fact finding. Again, the idea is they don't report to any of the operational units, so they can go in, take a look, and not worry that they're saying something critical of someone who's at the desk next to them or reports to the same supervisor. And then they share that information with whoever the relevant decision maker is, so they can decide, okay, based upon these, based upon the evidence and what that indicates is the most likely events that happened, how does that apply to our rules, and then what type of corrective action should we take? So those are all services provided either directly by General Counsel's office or in one of the affiliated units. The last area is management of outside legal services. So it's not possible for 2 of us to handle all of the requests for legal services at the college, and there's lots of very specialized areas of law that would not be appropriate for us to give detailed advice. So for example, I don't have a background in real estate or construction law, so when we've had issues about purchasing real estate or we're trying to set up a complicated construction contract, we go hire outside counsel, someone who's spent a significant part of their practice in that specialty area, so that we're getting advice for the college from someone who's very knowledgeable about the subject matter. The other time when there's outside legal services, it does happen sometimes that there's what would seem to be a conflict of interest. It's for one reason or another having college employees who are also lawyers, but acting as the lawyer in that situation may not be the most appropriate, and so we hire outside counsel to perform whatever those services are. Excuse me. So a little bit about outside legal services. So the college works with a number of law firms, as I mentioned, well, for a couple of reasons. One, because sometimes there's a specialized area of law where we need someone who's really expert in that. The other is sometimes it's just capacity. We have a really large project. Seth and I don't have time to devote, many hours to a particular project, and it's better to outsource that project. For when I started at Pima, the college was already in the process of issuing an RFP for legal services. So there was a request for proposals sent to law firms all around Arizona. A number of them bid. We picked, I think it was 5 of them, and they were all sort of then pre-approved to provide legal services. They gave the areas of practice that they would provide assistance in with pricing. We've moved away from that model more recently. So the university system in Arizona just went through a comprehensive request for proposal system. So they put out an RFP and selected a number of firms, and working with our procurement department, the university system was kind enough to put in the language in their solicitation in their contract so that public entities like Pima can piggyback on that contract. So we get basically the same pricing we had before under now what's a university solicited, negotiated, vetted contract. So instead of us going through all the work of doing an RFP process, we're piggybacking on the state university system. One advantage of that is it actually gave us access to a much broader range of legal specialization. If we need it, we typically don't, but if we were to need it, there's a lot more firms we can choose from. Then lastly, the college has comprehensive liability coverage through something called the Arizona School Risk Retention Trust. That is a pool, if you will, of the K-12 districts in Arizona plus all the community college districts except Maricopa. They self-insure, they're not part of this risk group. That risk pool, so think of it, it's like insurance, but essentially the colleges and the school, we're the members of the insurance pool, and members from, representatives from the school districts and the community colleges are the board of trustees of this risk pool. Insurance basically comes with 2 benefits. So one is indemnity, which means if the college has to pay a claim, there's a car accident with a college vehicle and it's the college driver's fault and we have to pay to repair the other car, the trust pays just like your auto insurance would. That's the indemnity piece. The other component of insurance of liability coverage is defense, which means that when claims are asserted or a lawsuit is asserted against the college, if it's potentially within the coverage provided, the trust assigns legal counsel that represents the college. They pay for that. We do have a deductible, but it's essentially paid for by the trust. The legal fees are paid for by the trust. One of the aspects of that that's just important to keep in mind is that those lawyers, even though they're hired by the trust and they're paid by the trust, have the same obligations to a client as any lawyer does under the ethical rules. So the college is the client, not the trust, right? So they owe their responsibility to make sure they're giving good advice, that the college is well informed to the college, and whatever recommendations they make, they're making because they think that's what's in the best interest or what should be considered for the college, not the trust. So they owe their duty of loyalty to the college. The other, I guess, one aspect of that is once in a while, this is very rare, we've had a disagreement with the trust about coverage. That lawyer will not deal with that issue. We will get a separate lawyer to do that because it does put them in an awkward position, and we don't want to have them or anyone feel like their judgment is compromised because the trust and the college are not 100% aligned on a particular issue. I guess the last thing I'll mention about that is typically when the college is has legal counsel assigned by the trust, and they're working with us to represent the college in defense of a claim or a lawsuit. If the claim appears to rise above a certain level, or we're going to have a conversation about a settlement or a significant event in the litigation, then we will bring that litigator to an executive session so you can hear directly from the lawyer who's litigating the case. So that's an example of, in the past I did litigate cases, but I don't have time to do that with other responsibilities, and it's not the focus of my practice, so I'm not going to be the best person to represent us in a courtroom. We need someone who that's what they do every day for different clients. So when we have a significant litigation or claim situation, that person's going to come in and speak directly to the board so you can hear from them. Here's what I think the issues are, see what questions you have, and then they're in the best position to share with you what they think could happen and what decisions the college has to make. Okay, so that's a lot of information, but I think hopefully that gives a reasonable overview at least of how it works. If you have particular questions now, I'm happy to try and answer them, or if there's other aspects of this you'd like more in-depth, then we can certainly arrange for that. Yes.
Thank you, Jeff. So a couple of things that I have experienced in the past anyway is that I totally understand, and I believe we all understand that you are the representative of the college as a whole, okay? And in my view, in my opinion, I don't know if anybody else agrees with that, but the fact that you report to the chancellor, it would seem to me anyway that it would not be a fair resolution on issues, because your ultimate responsibility is to protect the college, okay? So if you have an employee dispute, for example, on Office of Dispute Resolution, and they're reporting to you, okay, and you know for a fact that perhaps some of the issues may have been violated, and even if that other person's issues were violated as well, the defendant, I will call them the defendant, the person filing the claim, I don't see how the office or you could do a fair assessment of a situation that way. And specifically, and I could be wrong, but on the Office of Dispute Resolution, what they do, they just investigate. They don't have anything except, and then furthermore, even when you have legal services outside of the college, you direct them per the college on how they need to proceed and what they should investigate and what they should not investigate. Is that not true?
No, not exactly.
Excuse me. But I have heard that when there were some investigations being done, that in fact people were told that they didn't want, the investigator didn't want any more information, that's not what they were asking. So
Well, so that may not be the same thing, so let me see if I can address, I think there was a few issues in there, so let's see if I can address them. So one is, well, what happens if there's an investigation of an employee at the college, and it might involve more than one employee, and there's evidence that suggests that maybe both of them, one or both of them violated some standard. So in that case, it's one of the reasons that ODR is not part of an administrative unit, because ODR is not going to be involved in disciplining either of those employees, and neither am I. The job is to make sure the decision maker has the best available information so they can make a really informed decision. Now, what happens if the decision is this person X violated some code of conduct standard? And so remember, what would happen in that situation is the relevant supervisor and HR would work together to come up with a corrective action. But let's say, and I'm not saying, just hypothetically, let's say the investigation is that employee 1 sexually harassed employee 2, that's what the evidence shows. If the relevant supervisor and HR didn't do something about that, then it would be our responsibility to go to the higher level supervisor and potentially the chancellor or even the board and say, we have a sexual harassment problem here and it's not being appropriately dealt with. That would be the responsibility. And it actually has happened where high-level individuals at the college at different times have done things that are not appropriate, and the result was that there was disciplinary action of some form. So it's part of the reason. There's an advantage of having legal counsel's offices. We're ultimately answerable to the leadership of the college, right? And at the end of the day, it's true that on a day-to-day operational level or for supervisory issues, legal counsel is in the supervisor line of the chancellor, but the highest level decision maker at the college is the board. So if legal counsel is not doing a good job in fulfilling those responsibilities, ultimately they're accountable to the board. So, I mean, there is an incentive from that. I mean, imagine what would happen. Let's say I knew that the chancellor was doing something wrong and I didn't report it to the board and the board finds out. Well, I have a lot of problems. I have a problem in my employment. I have a problem in fulfilling the standards under the state bar rules. So I'd have to be willing to risk an awful lot for that to happen.
Then I have one more that I'd like to address. Yeah. Okay, so anyway, so for example, you mentioned that as the attorney for the college, that if you see any wrongdoing and you address it with somebody, and then it goes to the next level, possibly to the board, okay, but who on the board do you go to? Do you only go to the chairperson, or would you go to the entire board to have a discussion on what the issue is? Because in the past, as you know, that did not happen. Only one person or maybe two people on the board were told of the situation, and then it went and it was escalated. Okay, so I would hope that in the future, each and every issue that has to do with any of the board members, that it goes to all the board members, that we all be informed. And you know what I'm talking about.
Well, I'm not sure I do specifically, and I'm happy to talk about that later, but if there's a complaint against the chancellor, it has been reported to the full board. I mean, it typically gets reported to the board chair first, but it does get reported to the board.
I'm talking about your report to the HLC, and your report to the Attorney General.
Well, again, with all due respect, there were no secrets here. I mean, things were communicated. Like I said, I'm happy to have an offline discussion with you about that, or however the board wants to do it. Like I said, ultimately, legal counsel is responsible to whoever the appropriate or highest level decision maker is, and the board is the highest level decision maker for the college.
So perhaps communication-wise, instead of going to the board chair and vice chair, that all board members be notified at the same time.
And we should all agree, because it is a board. It's not one person.
So there are situations where the entire board has not agreed on a course of action, and then again, the lawyer takes the direction from the authorized decision maker. So if the board votes and a majority of the the majority of the board votes in a particular way, then that's who I take my direction from. It may not be what the entire board wants, but that is the system we have.
So when I spoke with Chris Mays last year, I was talking to her about board governance, and she said ultimately boards are responsible not only to govern the college, but also to govern themselves. And so I think that that's one thing that this board is doing. We are putting energies and efforts into doing that, right? We're going to have a special study session, exec session, and we're going to talk about how this board interacts with each other, with the administration, with the chancellor, with the public. And I think that ultimately, we don't want to have you all in the legal counsel department have to go higher. We want to be given the opportunity that we can correct any inappropriate mistakes or on purpose behavior. Everybody makes mistakes, right? But so thank you for what you all do here, but also we want to make sure that this board is given the opportunity to self-govern ourselves also.
Sure, absolutely.
Jeff, it sounds like there was a lot of thoughtful effort made in the, at least when this all started 10 years ago, in terms of the structure. And I assume, and you don't need to go into like every step of how that structure has evolved over 10 years, although this was a great overview of that. Is there anything now that Pima is doing? Are we still kind of fulfilling the best practices of how the legal operations of a college should work, or is there anything structurally or otherwise that you'd be interested in exploring changing? I don't know if those are still the best practices that are out there.
So that's an interesting question. So for the most part, our model, the general model hasn't changed a whole lot over time, and it's partly because of, I think, the way colleges are structured and because of the rules that govern lawyers, right? So the rules of conduct for lawyers are not that much different state to state. The basics are the same. This is an issue. There is an issue at Pima and everywhere else. So some of the functions that I'm carrying out are not legal functions, or that Seth is carrying out. They're not strictly legal functions, right? When I'm supervising the internal auditor, I'm not doing that as a lawyer. I'm doing that as a supervisor at the college. So, for example, those conversations are not privileged because it's not an attorney. Sometimes there are aspects of them that are. So one of the challenges for any in-house lawyer, and this is why I say this is just everywhere, is trying to make sure there's a good understanding of which hat you're wearing when, because there's different rules that apply. When the lawyer is acting as lawyer, there's privilege and some other benefits that attach, but other times the lawyer is acting, like in this case, as a supervisor. And so why that's important is, so for example, if, I'll just use the internal auditor, not to pick on him, he's a great employee, does a great job, just top of mind. If I had a supervisor issue with him, or there was something about his employment that raised legal issues, I can't be the lawyer for that too, right? Because I can't, at the same process, go, well, when this was happening, I had the lawyer hat on, so it's privilege and it's legal advice, et cetera. And this time I had the supervisor hat on. So there's situations when those distinctions have to be recognized, and what you'll hear lawyers say is, it's a challenge sometimes, right? So if you're supervising a unit, compliance, audit, whatever, you have to be very mindful of that as the lawyer, and then you have to try and make sure you're always reminding everybody about that, because sometimes you have one hat or the other. So I'm not exactly answering your question because there's no good solution to that, and in a lot of institutions, the size does not permit us to have high-level heads of everything. So it's fine that we have the model, it's something that we have to be really mindful of, and we try and make sure everyone else is mindful of, is in what hat are we wearing in what arena. So in an ideal world, you might have an institution with a chief compliance officer that reports directly to the chancellor or president. That's not the way it is at a lot of institutions, because there's only so many people you can have and so many resources you have. So it's just a challenge to be aware of. The model we have and the functions that are sort of assigned to the legal department are pretty common.
Great, thank you.
I have one more, and please let me know if I'm out of line. Okay. So a couple of things have come to mind. Number one, I would hope that the board would have its own legal representation. Number two, when you have people that are investigating employee disputes, that somebody outside of the college should be investigating those issues, not somebody within the college, because I personally can't see in my own mind, and like I said, I could be wrong, that how you can be objective when you're representing the college, because that's your primary responsibility. So if an employee comes forward with a complaint and they do an investigation and it isn't what it should be, and they continue to complain, I think the only way that could be resolved amicably is if it was an outside counsel.
So there are times when we hire outside counsel, but I guess I'll suggest I look at it a different way. If there's someone at Pima who's doing something that they shouldn't be doing, then I am protecting the college by making sure that that is addressed in some way. Hopefully by that they voluntarily change their behavior or conduct. Sometimes though it's by discipline. So, and the view I think the view that you're sharing, I know there are other people who have that view, and sometimes they think when a lawyer says they represent the client, they're trying to protect the client, what they means is that they bury every bad thing that happens so it doesn't come out, and because that's bad for the client. What I would suggest is that does mean I'm not in a hurry to go parade around town and share things that are not good for the college. But if there's a problem in the college, at least I think what you'd hear most lawyers say is then it's their responsibility to make sure someone in a position to do something about it knows so they can fix it, because if you don't fix it, ultimately that could cause a really serious problem for the client. So the best way to protect the client is find out about problems and make sure that someone is addressing them in an appropriate way.
I have a question about 6.01 as it pertains to the relationship between general counsel, chancellor, and board. Would you rather me hold that till policy 6.01 or do it now? You're the boss.
You're going to talk about that in our next section, aren't you?
If there's a specific question about it, I'm happy to do it either then or now, whatever you prefer.
Looking at our policy, you report to the chancellor. General counsel reports to the chancellor. The chancellor is responsible for the supervision of general counsel, including, I suspect, the evaluation and the salary of that position. Is that correct?
So legal counsel reports sort of operationally to the chancellor. Again, there's rules of professional responsibility and some specific language in the board policy about going to the board if necessary. Yes, the chancellor does the evaluation for legal counsel. Compensation is set by the HR system. Right, so my job is matched up with other positions at the college as roughly comparable, and so then I'm on that. So I'm not on a separate pay scale from any other administrator at the college. I don't know if that is answering your question.
Sort of. If the board is in conflict with the chancellor, who's the top responsibility for guidance with the general counsel?
So for example, let's say that I thought a chancellor, not this one, a chancellor, we're doing something inappropriate. I would call the board chair, let them know there's a problem, and we need to have a conversation with the board, because I can't convince the chancellor that they're doing something that's not right. So my ultimate responsibility would be to the board. The other way that that's true is, I know when we talk about general principles of good board governance, right, one of those is lots of organizations will tell you the board only directly supervises one employee, the chancellor. That's true. There's sort of a caveat with that. If the board, a majority of the board, decided that legal counsel was not the right fit for the college, the board is the ultimate decision maker for the client, and that is their prerogative, right, to have legal counsel of their choosing. So that's the other constraint on what legal counsel does, is ultimately if the board collectively decided the legal counsel is not doing a good job or not fulfilling their role, then they could let they could let legal counsel go.
So let's assume we had a situation where it didn't result in the board instructing you to terminate the chancellor, but it meant some form of disciplinary action that was going to be distributed to the chancellor through you. and then that happened in February. In April, you're sitting in the chancellor's office for an evaluation on your job performance by the same person that you just implemented discipline with. Am I reading the policy correct? Is that the way that process would work?
So that could happen, and then I'd be talking to the board again if I thought that happened. So that's one reason why. Let's say there's a sensitive allegation about the chancellor doing something wrong. So that might be a situation where that comes to my attention. I can't dissuade the chancellor from that course of action. So I'm going to call the board chair. Hey, there's a problem. We need to have a conversation. It goes to the board. In that conversation, one likely outcome is the recommendation of let's get outside counsel to do the investigation of the chancellor and advise the board. So then I'm not in that situation. I mean, I would do it if I needed. That would be my job, and I would do it. But yes, it could put me in an awkward, or the college in an awkward situation, and that would be a really good situation where you'd say, let's get outside counsel to do that. So a parallel, but not quite as serious of that is, in the past, there have been some level of negotiations between the college and the chancellor on contract and salary. My client is the college, but I work every week with the chancellor. So in that situation, one of the outcomes of that was it was easier to say, well, chancellor, for sure, you have to get your own lawyer because I can't represent you in that conversation because I'm taking my marching orders ultimately from the board. And that may also be a situation where we say, we're going to have the board, we will hire outside legal counsel to work with the board in the negotiation with the chancellor and their lawyer, and then I'm not in the middle of it.
So at that point in time, if the chancellor wanted legal representation, that would be a personal responsibility on the chancellor's part.
If the chancellor wanted legal representation in that situation, the legal counsel's office at the college could not represent the chancellor in that situation. There would be a conflict of interest. They would have to get separate counsel. Whether the college chose to reimburse them or whatever would be a different conversation, but they would have to have separate legal counsel because in-house legal counsel takes its direction in that situation from the board, not the chancellor.
I just think this was an important conversation for everybody to hear. And at this time, until we get to 6.01, I'm finished with the line of questioning. However, my last question is, you still feel comfortable with the wording in 6.01 that general counsel is ultimately reporting to the board and not the chancellor?
Are you asking me do I think it's clear enough? I think it's okay. If you wanted to make that even more clear, we could certainly do that.
Well, first I want you to hear that's the case, that you are the general counsel of the board, not the chancellor. And the second part of that is, does 6.01 say that clearly enough?
I think it does. They said the other sort of protection here is it specifically references that legal counsel will follow the Arizona rules of professional responsibility, which there's no question what that rule is when the client is an organization like the college.
Thank you.
So I'll amend my prior response on the advice of counsel. It's a good point. So I'm general counsel for the college. The college is the client. The board's not the client, right? The board are the highest level decision makers for the client, which is the college, right? So that's why, for example, if a board member did something inappropriate, my responsibility is to the college and the board as a whole, not to the individual board member, if that makes sense, right? I'm not your lawyer per se, I'm the college's lawyer, but you are part of the group that ultimately makes the final decisions on behalf of the college, if that makes sense.
Well, you open this door. The college is not going to tell you what to do.
Say, organizations can only operate through people, so at the end of the day, the board is the highest level decision maker that sets the goals of legal representation.
And the
right?
board will always act with the best interests of the district in mind. So therefore, if you get any kind of direction from the board, it's always going to be in the college's best interest.
And it should be the
We
entire
certainly hope
board.
so. the majority of the board. It may not be unanimous. That's why I say it doesn't. There may be times when I can't take direction from every member of the board because you all don't agree on what that direction should be, right? So in those situations, it's what the majority of the board decides is in the best interest of the college and the goal that the lawyer is supposed to implement.
All I can say is, phew. I had to look up a couple of words, by the way, in some of the legal documents that were given, which I think is good because we should always be expanding our vocabulary. So thank you for that.
You're welcome. If they're in the college documents, we could certainly fix that.
They weren't in the college documents. They were in some of those legal service model rules of professional conduct, et cetera.
Yeah, I'm afraid I can't change those.
Thank you.
I will turn over the floor.
Okay. And now we're moving straight into section 3 for discussion and action items. First is 3.1, review of board policy updates. So I just have a couple of questions that I would like all the presenters to be able to answer in some way or form. We call these board policy updates, but the board, the 5 of us, have been involved on 0 of them up to this point, except for the one I wrote, but the rest of those people weren't involved in that one either. And I'm just wondering, it seems odd that board policies would have revision dates of, you know, May 22nd, May 23rd, June 12th, May 11th, and now we're in November, and this is the first the board has heard of them. So I'm wondering what the communication, what it's supposed to be, because I think if we're calling these board policies, there should be some sort of communication prior to 6 months later on some of these, is sort of what I'm feeling. And let me see if it was, so there's 2 parts, right? Why aren't we more involved if it's board policy, and why are we calling these revision dates 5-6 months ago?
So that's probably bad labeling. That revision date is the date of when the proposed changes were finalized. It's not the date the board policy was revised. So if you go look on the website now, it reads exactly the way it did before. So it has not been changed on the web. So that's probably a poor choice of words. They weren't revised, right? They're proposed to be revised. So how much should the board be involved? So that's part of why we're having this study session is administration in consultation with the governance groups or AERC or other stakeholders, depending on the policy, is making recommendations about changes that should be made. And the board policies that are in the grouping tonight are kind of in 3 categories, right? One is no changes suggested. Another is what we're calling minor revisions. You know, the name of this office isn't right anymore, or maybe it's to simplify the language a bit or something like that. And then there's one where there's significant revisions suggested. So one of the reasons for this study session was if there are any of those where a board member reads it and says, oh, I think we need more in-depth conversation, or I have some ideas about change, then that's what we want to know, and we'll figure out then more of a dialogue process going forward. But for some of them, they're board policies that seem to involve some fairly general or high-level principles that probably don't need a lot of changing, or at least that's the idea. So if there are any of those that need significant discussion or revision, then that's kind of the point of tonight, is to find that out so that that can happen before they're up for a vote. So the board's not voting on any of those tonight. That's the point, is to have this conversation. So if there are items, this is the perfect time to make that known, and then we can figure out how do we go forward to make sure that there is an appropriate level of dialogue. But what you're getting is there's been this input process, and then here's the thinking.
So I have one more question that just came to mind. As I was reading through all of these, and I didn't read both versions, I just read the draft version, so it had, you know, what was marked out or added or whatever. There are quite a few things on there that I know didn't happen, at least in the last 11 months. And, you know, I watched through a bunch of board meetings last a month ago. I watched through all the board meetings from November 2017 to present. I did it on 2.5 speed, so it didn't take all the hours all of you had to take when you were actually living through it in the audience, et cetera. And there are a lot of things that are in those board policies that, in my opinion, never happened in a board meeting. And so my question for you is, and I can, some examples, one is being deleted, but it was the chancellor's travel. The chancellor would report to the board, and so I'm assuming that that should be in a board meeting if it's that high-level board policy thing. So whose responsibility is it if we have these board policies? I don't like rules that we don't follow or we don't abide by or we don't really care about. Why write them? Why have them in writing? And so there's a lot of things that somewhere I think I read that it was directed that the chancellor the chancellor would have all of these board policies reviewed and revised as needed every 3 years. And since most of our board policies were revised last in 2017, obviously that didn't happen. So whose responsibility is it to make sure that these board policies are upheld? Is it the board? And if we don't have any input into the policies, that seems not fair. And if it's the people who are supposed to do the work, it's just sort of a vicious cycle, it appears.
I mean, so the answer of who's responsible, I think the real answer to that is all of us are responsible, right? So it's the board, it's administration, it's the different units. Everyone has a share of responsibility for trying to make sure that board policies are reviewed and updated at the appropriate time. There's no magic to the 3-year review. That's the decision that was made when there was a significant overhaul of the board policies in that 2013 to 17 timeframe, maybe even to 2018. And at that time, the decision was that every 3 years was an appropriate interval. So that's a college decision. We may decide for some board policies that's too short, maybe for others it's too long. So I mean, that actually would be a good conversation to have, is what is the appropriate interval. Presumably, board policies shouldn't change all that much. They shouldn't change really frequently. And why I say that is the board policies are this overall framework structure for the college. And so if they change a lot, then you're changing basic standards or goals that the college has to meet, which doesn't mean the board shouldn't do that. There are times when it's entirely appropriate. But for the most part, you probably wouldn't expect to see board policies change a lot every time they're up for review. It still doesn't get back to one of your points, which is a fair one, and we've had some internal discussions about this, is we need to come up with a better system so that we as a college collectively stay on top of this and have reviews in a more timely way in accordance with a better system so that people feel comfortable that things are being reviewed and updated in a timely way.
I'm not sure, Jeff, but are you Lisa Ann? You're, so I don't know if we need to hear from Lisa Ann, especially if you've prepared something. We'd love to offer you a time to speak about outside legal counsel, if that's something that you all are interested in doing.
I did not prepare something, but I am prepared to discuss with you the role of outside legal counsel to whatever questions or information you want me to provide. I can do that.
Okay, thank you. I would hate if you had something prepared, drove all the way over here, and then we're going to pass you by. Does the board have any questions for her from her area of expertise? No? Okay.
Is she going to do a presentation? I don't.
Okay. Okay.
We're here because we were going to talk about outside counsel and the trust counsel, and she's been both of those roles, so I thought it'd be helpful. But like I said, I know enough to be able to give you the basic description, but if you had specific questions, she's better versed in that than I am.
Is she going to be participating in our exec session today?
No.
Okay.
I guess the other thing I'll offer her services. If we're going to have a future conversation about BP 601 or a different part of the legal services model, we can certainly invite her back.
Yes.
I have sorry, just to follow up on what Teresa was saying. Does the college use there's a lot of policy and compliance software systems that exist now. I mean, lots of businesses use them that automatically triggers updates and, all of those things. Is this just sitting in a file storage somewhere, or is there a system that I generally don't know what system the college is using to not only the board, but probably policies in general?
So we have been using Smartsheets and some other tools to try and automate and track it better. There are some specific board policy management software tools and compliance tools that we've been looking at. They're really expensive. Doesn't mean we shouldn't do it. We have not picked one or decided that that is the best course of action. I mean, one of the challenges we have, so this is just to be candid with everybody, policies and procedures don't always get to the top of people's list because there are things that seem really urgent, right? And it's a board policy, it's not due for 3 years, I don't need to look at it. It's very understandable. That's not an excuse for we haven't kept up with the schedule that we set. There's just been a reality that in many areas of the college, there are a number of policies and procedures that have not always kept up at the rate they should, like I said, because it doesn't seem to be the most pressing thing at the time, and people devote their energies to items that seem to be much more time sensitive. And so it's an area that doesn't always get the level of attention it needs. We have to figure out a better system so that that's not a problem, and maybe one of those software packages is an answer. We've looked at a few of them to see if that might help.
And for better or for worse, I mean, it's your decision if you want to use it or not, but I will say in all of my regular employment, my current one included and past ones, I understand that dilemma, because I certainly, as I'm in my day-to-day, updating a policy that I haven't looked at for a year isn't always top of mind. But I will say, those systems hound you, and it hounds me daily sometimes about updating things, and sometimes it does take that level of automated hounding for me to go, fine, I'll update the thing and then get it through. So for what it's worth, they provide a little value in that way.
For systems we've looked at, that's one of the factors we've looked at as to whether we could set it up to do that automatic, just keep pinging people with reminders, and maybe that would help.
I have one more question, Jeff, if you would not mind. So I asked you recently about that 21-day comment period because I had heard that there wasn't a 21-day comment period for some things, and you answered me, but will you cover that again about the 21-day period? And the reason I'm asking that is the 6.06 is one of the ones that was revised, the intellectual property ownership. And when I started to read that one, I thought, I don't know anything about that, but I'm sure there are people out there in the world who do. And so I was just hoping that that would have been one of the ones that did have the 21-day or will have the 21-day comment period, because I think that's really important. So thank you.
Sure. So I'll just add one piece of context that will maybe help you feel better. There's an AP, an administrative procedure to implement the board copyright policy. We're putting together a working group with help from the library staff, because there are library staff, faculty who are very knowledgeable about copyright and intellectual property, to be part of this group to look at kind of the meat of some of the issues that the intellectual property policy raises, issues that really need some better fleshing out at the AP level. So we do have a working group starting on that. To answer the broader question, so what's supposed to happen in accordance with the, so we have a policy on policies, right? It explains, kind of provides some definition and a framework for how this is supposed to happen. When there is a BP or an AP that it gets reviewed, and there's either no changes recommended, or what we call a minor revision is recommended, there's still a notice that goes out in @Pima News, and it's still posted on the board development, the policy and administrative procedure development webpage, saying, hey, these items have been identified as either needing no change or substantive revisions, of not needing substantive revision. So if someone disagreed with that and said, no, you missed something, you really need to have this new aspect covered, they could write in a comment, contact the chancellor's office, and that information would go to whichever unit is responsible for them to consider, because maybe there is a change that needs to be made. So it is posted and included in the regular newsletter for with a period of 21 days so that people can share that if that's their perspective. That's what's supposed to happen. I believe it happened with these. If it didn't, I'm happy to double check and make sure that it did. But there should never be a board policy or AP that goes through without having been posted in some way for people to comment on, even if there's no change recommended.
Okay, and I promise this is the last one. So on board policies, when folks make comments during that 21-day period, I know that there's some system out there to, read them and type them up or whatever. What is the policy about the board hearing those comments and those suggestions or criticisms or whatever?
So good question. First, let me clarify what happens with the comments. So there's a central email address. All the comments go staff, Angie Wesson, puts all of them into a chart. She groups them by topic because sometimes some of the comments have a similar theme to them. Those comments go to, again, whatever unit is coordinating the review process so they can look at them. They put in responses in the chart. That is posted as part of the policy development page so anybody could see the comments and the response. That's a good question about, in this case, whether all of that went to the board or not. I'm assuming from your question that may not have, so we can certainly get all of that to you. But normally, and certainly what I envision with BP 1.25 is all of that commentary would go to the board so that you can see what different people said and take that into consideration when you decide what direction you ultimately want to go.
So I misspoke. One more. Do the board members have access to that policy and procedure development webpage?
That's on a publicly facing web page. So yes, you have access to it. Maybe what Andre and I can do after the meeting is make sure you know where it is on the website. And like I said, the other issue is if that's not sufficiently accessible or convenient, we could also come up with a system so that we just send it to you separately.
So are we going to have people present on these different board policies, or?
There are people available who could speak to them. The question is whether you want that or whether if there are questions about specific policies, we just want to deal with those. So whatever the pleasure of the board is.
Any other comments? That's what we're talking about right now. There are a few that I need more time before I personally vote on them. So can we sort of treat this like a consent agenda and withdraw the ones that we need more time if we want to make a motion and pass the ones that have already been worked on?
So none of them are in front of you tonight for a vote. The ones that are no revision or minor revision are on the agenda for Wednesday night to vote. So I think the idea of treating, so in effect they kind of are on the consent agenda, but not tonight, but for Wednesday. So if any board member would like to have further conversation about them, letting us know tonight would be great, and we can pull them off of that list. Or if you want to think about it overnight and just ideally before the meeting on Wednesday, let us know, here's whatever, these three I think need more conversation. Fine, we'll pull them off the agenda, and then we can figure out when to schedule probably a study session, follow up, a more in-depth conversation.
I agree with that. I read them, and most of them are just simple fixes as far as I'm concerned. I would recommend that if a board has any concern about any of the no changes or minor updates, we pull them. The rest of them go to the consent agenda for Wednesday, and that we totally take off BP 1.25 for a lot more conversation before we start talking about changing sentences, and because I believe we have to have a conceptual conversation first with the chancellor and amongst ourselves on how we're going to govern this place. and the role of the board, the role of the chancellor, and the relationship between the board and the chancellor before we get into revising the policy. And I think that's going to take another conversation all by itself. So, I mean, I would recommend if you have questions, we pull them on the minor updates with no changes, otherwise we move them forward to Wednesday night.
And then for Michaela Hayes and Aubrey Conover, I have a comment for you, comment/question. In one of the documents in that board policy 1.25, or maybe in the presentation, I'm not really sure where I saw it, I saw something about Maricopa, how Maricopa, they only have their, I don't know if it's full-time faculty, some word like that, that they're involved in. I was told by an attorney up there in Maricopa that the board approves faculty and staff. And on the one that is presented to us, it has staff and adjunct faculty as their board doesn't see. When I clicked on the link for the staff, it took me to one of their board policies. So just check on that if you can between now and Wednesday, because if Maricopa's board approves their faculty and staff, but they're not approving adjunct faculty, but we're saying that that it's different than what it is, it'd be good to have it accurate. So if you could answer that question for me.
So we can look again, but so I went to the Maricopa, and if you click and you read the board policies and you read what's in the agreements, there's sort of 3 different categories. The non-faculty staff and adjunct faculty handbooks are approved by the chancellor. The board has entered an agreement about terms and conditions of employment with the Maricopa Faculty Association on behalf of all of what they call the residential faculty. That's the equivalent of regular faculty at Pima.
So when I clicked on the residential faculty, it took me to a page, and when I clicked on the staff, it took me to a very similar page that looks like it's board policy. And when I clicked on the adjunct faculty, it took me to a completely different one that wasn't under board policies.
So maybe what would be helpful is maybe there's an issue with the links. So what I'm thinking is, why don't we go pull the relevant documents, and then we can, or some of them are really long, so we could pull the relevant sections or policy, because maybe it's a link problem. So because that was cut and paste from a document and put into a PowerPoint, whatever. So that may be the problem. So we can fix that.
I just think it needs to be, more clear, because if we're voting, assuming it's one way at Maricopa, but it's not that way, then that would be sort of, Anyway, thank you.
Yeah, sure. We should get the background documents for you. You can read them yourself that way.
Can I give more information on what you mean by when you were saying that discussion? I mean, I'm not opposed to it. I'm just trying to understand. And the only reason I'm curious is I'm cautious of how long this has taken us. Like, I mean, from the time that Teresa introduced the first revision, and then and appropriately, went through the college process. But it's my understanding that process has produced a policy that's consensus driven in like 97% of it, except for a little bit of it. And so I worry a little bit the consequences of what you said, Wade, were like blowing up all of that, because it seems like the process is working well. I mean, except for that one piece. And if we can do that quickly, I'm not saying I'm opposed to it. I want to be timely in what we're doing, and because this seems like it's dragged on forever, and I also don't want to disregard all the work that has gone into trying to drive that consensus and all the compromises that have happened so far. So anyway, if you give me more information about what you meant, I would like to understand that more.
Okay, thank you. This board is amazing, by the way. We work really well together, so thank you for all your comments today. And we are moving on now to section 3.2. Do I have a motion to move to executive session?
Sorry, did you want to hear the presentation about the different versions of BP 1.25, or were you saying you wanted to? Sorry, maybe I was not understanding correctly.
I think it might be good to develop our understanding of where we are, and that even if there is a subsequent discussion that, like what Wade's describing, at least could be informed by the work that's been done so far. So I don't want to have everybody come out for nothing.
Okay, so Aubrey and Michaela, you guys are up. Thank you.
Actually, if you don't mind, Madam Chair, if we could have a general overview first, and maybe General Counsel Seth Shippey can provide a brief overview of the revision process. And then we can have Aubrey co-chair and then Michaela, the other co-chair, give their perspectives. So how about if we start with Seth? Just to give us feedback, to give us a background information of the process.
Well, thank you so much. We're going to bring this up. We have it structured exactly as the Chancellor articulated. So Seth is just going to walk through the steps that we've taken so far so you'll have an understanding of who's been part of the conversation. And then Michaela and I can talk about where we're at and where we would love some guidance. And I don't know how to, get to the full screen. Perfect.
Well, good evening, board members, Chancellor. Thank you for indulging me for a few moments. I promise I'll be very brief, but we did think all of us thought it was important to give you a little bit of context for how we got to where we are and to give you a little bit of background on the information that the co-chairs of AERC are going to be providing. So consider this, if it was a television show, this would be a previously on section right before they get into the content. So, as Jeff was explaining, we have a process for revisions to our policies and procedures. Within that process, there are different branches that the process could take depending on the subject matter of the particular policy or procedure. Broadly speaking, that breaks down three ways. We have things that are mainly academic issues. We have things that are college-wide issues, which are going to be most of the board policies and administrative procedures. And we have a third category, which is personnel policy issues, which have a specific process that they need to follow. And that's circled in red. If this was a PowerPoint presentation, that would pop up and it'd look great. But just consider that that's why we're here tonight, is to talk about category 3, personnel policy issues. So that's not it. Okay, so personnel policy issues, what are they? Well, within the shared governance process, those apply specifically things to that policies, procedures, and handbooks or manuals that directly and substantially relate to wages, salaries, and working conditions. So if we're within that category and employees want to share their input with the board about those particular issues, we have the AERC. So employees have their various representatives for the constituencies of employees, and AERC then will take that feedback, discuss it amongst themselves, and then produce a recommendation, hopefully by consensus, to whoever the operational unit is for that particular, who's responsible for that particular bit of policy or procedure. Typically, since we're talking about wages, salaries, and working conditions, that's going to be the Chief Human Resources Officer, but not always. So just to give you an idea about what some of those might be, the Employee Code of Conduct, performance evaluations, how those are conducted, benefits, things like that. Those are all things that are considered directly and substantially related to working conditions, such that they would be subject matter for AERC. So here's where we get to the previously on, the BP 125 revision process. So basically there's 6 steps. What's highlighted there in purple, the first 3 things, those have already happened. I'm circling the AERC resolution team there because that's what Aubrey and Michaela are going to discuss with you. On Friday, we all went before the Staff Council and the Faculty Senate, gave them basically the same information that we're giving you tonight. And that brings us here to step 4, which is tonight's study session, where we're going to tell you what we have to say, and you'll have an opportunity to get some input and to get a more fulsome understanding of what's going on, how we got here, and where we go next. Speaking of which, highlighted in green here, those are the next steps that will happen after tonight's study session. So depending on what the board decides to do, if you wanted to table this and come back to it later or have more discussion, that's all going to happen. And then if it changes, if you want AERC to do something differently, that would go back out to the governance groups and back out for public comment, all in due time. And it is a slow process. But in the end, it is a board policy. So the final decision is going to be with the board. You will decide what it is. More or less take it or leave it from what AERC has to suggest. You could go your own direction completely. So with that, I will hand this over to my colleague Aubrey, because where we have come is AERC has had a full discussion, and most of the time AERC is in complete agreement on everything. And as Aubrey will explain, that's basically the case here, but they do part ways on one particular issue, and it's an important one. And so with that, I'll hand it over to Aubrey.
All right. So, yeah, I can't stress enough, and, Mr. Taylor mentioned this, we have a really good process in place. We are able to work collaboratively and come to consensus on 99% of the different things that we face. But there are times, once in a blue moon, where we can't come to that final consensus. And that's what we're talking about this evening. And it goes to kind of some of the fundamental things about the relationship of the board with making decisions that come before them and who makes that decision. So as you'll see in the language that we've come to consensus on, we have recognized that there's some areas that we all need to work on that would make it a better process. And really coming down to that last piece is whether it is the board giving direction to the chancellor or the board making the final decision. We're going to kind of talk through kind of some of the pluses and minuses on both those. Here is just the articulation of those two different possibilities. Again, I want to stress that we've recognized that there has not been as much communication with the board on those rare occasions. Both versions try and address that by making sure that the chancellor at a minimum is informing the board of the different pieces and why the final decision was made, and then the disagreement is just who would make that final decision. So one of the things that the administration, in terms of our conversations, really did recognize is the fact that previously, if there was disagreement and it went to the final decision maker, it didn't often come to you. Sometimes, an employee might come forward and probably comment and raise a concern, but you may not be aware of if there was a challenge. One example that we love to bring up, because it's one of the few, is wearing our name badges. There's still disagreement, and at some point it probably will come forward to you all again about whether or not this is an appropriate thing for us to require our employees to wear. So that was one where we did not come to consensus. There are strong views on both sides, and administration made the decision that we should require these, and we went forward on it. But I'm not sure if that came forward to you all. Either way we go forward, these are going to come forward to you and say, this is why the decision was made, this is where the disagreement was, this is the strengths and limitations on both. So one of the things that, and Chairwoman Rial mentioned, community standards, so we'll show you a chart here that, we're kind of consistent with what the other governance areas across the state are doing. Doesn't mean we have to do that, but it's consistent. HLC is great about giving broad strokes, but not giving us a lot of definition. So one of the things we're trying to work through is how do we follow that HLC guidance where there is guidance and see where we can be consistent. Our current policies that do talk about this, talk about the day-to-day procedures that are delegated to the chancellor and or their designee. So this would be consistent in terms of staying in line with some of those BPs that you can see up there. HLC. So in the past, we have struggled at times with HLC finding the best balance between the role of the board and the day-to-day operations. So one of the things that we're trying to find that balance with this policy is where's the board's role in giving guidance and oversight rather than to day-to-day decision making. it's not always real clear with policy. Some of our policies are very broad when we talk about these, some are very small. So, you know, the days we have holidays or the time off hours are something that the board may or may not be wanting to be involved with on those day-to-day decisions, whereas something more broad, compensation or some of those things, you know, the board would definitely want to be part of that conversation. And so we're trying to find that balance between those two and distinguish between, you know, those overall policies and day-to-day procedures. These are some of the examples that are up there. We will get clarification on Maricopa because they do have a unique system. But in general, you can see that the policies for day-to-day decision-making are designated to their chancellor or president, depending on the titles that they carry. And once again, this is just kind of where we have the two different versions. And I can't stress enough that, you know, we've been able to come to real consensus through all the other pieces and implemented some things that I think are going to continue to make us stronger, regardless of which direction we end up going. And I think this is where I'm going to turn it over to my colleague.
Thank you. Just in case you don't know me, Michaela Hayes. So I have 2013 in here, and after Friday's presentation, I heard it may have been closer to 2017. There was a change in 2013 with creating the AERC, so it may have been closer to 2017 when it was implemented, but the ideas are there, and I apologize if I got the date wrong. I put it together fairly quickly. So there was a change made basically at that time to move the authority for the creation of the working conditions and compensation policy from the board to the chancellor. And what the employees have noticed during that time is the structure kind of diminished the employee voice within the process of policy creation, and it kind of created an inequity within the structure that can be difficult to work with. I like to compare it to a parent with a child. Like, if you have a parent that is really interested in hearing what their child has to say, they can get a lot of good work done and shared ideals. If you have a parent who is not, the child has no say. And so the structure of that system makes sense. And so regardless of how well this is working or how well it's worked in the past, we really look at this as something serious for the employees to be able to have a voice within the shared governance process. And creating this change gives weight to the AERC and to the discussions that we have with administration. We think this change would give administration another motivation to really negotiate or work with employee groups, giving us true representation within that shared governance process, regardless of who is at the table. This is not about people, it's about structure. And I love the quote that faculty and staff working conditions are student learning conditions. So it really is important that we get this done and get it done well. Okay. So what we're proposing is not the same as what we did prior to the board putting all the delegation to the chancellor. Prior to that, the board approved everything, every single policy change, big or small, minor or major. And it was all at once, and it was a big old packet, and we had a huge thing about it, and it was a lot. So instead, what we've looked at is if AERC and administration can come to an agreement, we would like that to go as an information item to the board so that you're aware of it, but you don't have to do anything with it. And then if we're not in agreement, that would be when it would come to the board, and we would be able to present the different versions with justification, discuss the changes, and then you could either give direction back to the AERC or the chancellor to go have more conversation, or you could make that final decision yourself. An example of that working well, I think, is this, BP 1.25. We have a fundamental disagreement on something. We've come to consensus as far as we possibly can, and now it's at your feet, and we're asking you to make that choice. An example where current policy was technically followed, but maybe not enough, so that you have that idea of one or the other. And again, this is not about a specific thing, but just so that you know where this change would affect process. The Office of Dispute Resolution complaint process is not in policy. Procedures and processes are not typically in policy, but it's such a wide impacting process that it refers in the complaint policy to any substantive changes should go through the AERC. And so there were changes that were sent to the AERC, but the feedback that AERC had really wasn't addressed fully prior to that process being made final and posted. Without changes to BP 1.25, it was followed technically, but was the spirit followed? And we believe employees should have the voice to say, hey, this wasn't followed fully. And without a change to the BP 1.25, we don't feel that's there. So what would come to you? How much work is this? We already have a system in place to work towards consensus. We have a tracking system on a spreadsheet. It's not near as nice as what Greg was describing earlier. I love those types of things that yell at you for you to get your work done. But we do have a system to track everything, and we have a system that has tracked how well things have gone. I would say that even under the current BP 1.25, there was maybe 2 things that might have come to the board in the last year and a half. So it's not a large amount, but the structural process would make more sense. And those would be the classification and compensation study, which you ended up seeing anyways, and what I just described in the ODR complaint process. So the big question is the employee handbook day-to-day operations? And my answer is no. But obviously legal had a different answer, so I will let you decide. So there is nobody here that wants to risk HLC accreditation. Absolutely not. And I do want to understand where that might be coming from. So what I've done is I've looked to see what could this be. And the HLC is an accreditor of community colleges and universities across the nation, many of which have collective bargaining agreements. You're going to see less than they would. So I'm not sure where that conflict might lie. Pima County, not a college, but a public entity, their employee handbooks and compensation and things go to the board. Maricopa College, we've just had that discussion. I'll let that go. And then PCC used to approve all policy changes once a year without change to the law, or without concern at the law. The only change I know of is how basically unions are compensated, and this is not changing that. So I'm not seeing the legal concern there. Happy to be proven wrong, but I haven't seen it yet. The other thing I did, and I'm not going to read all this, don't worry, is I went through the 2013 HLC action letter, and I pulled out every reference I could find to personnel policy. And the only things I found in there were actually calls for the board to be more involved. So I'm not seeing where the HLC concern would be for you stepping into this role. Maybe I didn't find it, but what I see is things saying the Board of Governors, I lost it, one second, lacked a robust committee structure to provide oversight of human resources and other functional areas of the college, which invites more involvement, not less. Also, I put a comment here at the bottom about the Human Resources Committee that y'all might want to take a look at real quick before your next meeting. And then the 2019 mid-cycle report, I did the same thing because I thought maybe I was just on the wrong year. So I went through the mid-cycle report and again pulled every reference to AERC or personnel policy that I could find. I did not see anything that limited your ability to take on this role that we're asking you to do, or even mentioned it. So the one part I did see, and I have the little curly brackets sitting there, is the mention of day-to-day operations. Everything in this section, everything in that policy is about our academic responsibility. It says faculty responsibilities are codified in the curriculum procedures manual. And then at the end, it says it provides sufficient evidence that the board's autonomous and delegates day-to-day governing of the college to the chancellor. So again, I think it's talking about a separate role, but even in curriculum, board program activations and deactivations come to you to approve. So I don't think we would have a problem here. And I think that is the end of that. But I really appreciate you taking this seriously, to taking a look at it. And this has been something that employees were very interested in really looking at this structure. Obviously, a larger picture is helpful. And I think if you're going to do that, I would encourage you to do it, but I would ask that it be done relatively quickly so that we can move this along. We have been looking at this policy and really trying to work on something along these lines since it was changed in 2013 or 17, whatever the official date was that we changed it. So it's been a long time coming, and I think this is a good compromise to continue to allow us to do good work. So.
Maybe before we go into questions, I'd like to invite David Borofsky to the podium. David is the interim executive director for AC4 and the Arizona ACCT, and he's going to provide some background information and additional context too. Thank you, David.
Thank you, Dolores, Chair Riel, board members. Fortunately, I don't have a presentation, so this won't be long. The conversation you're having is quite interesting, and I say that because you keep mentioning, everybody keeps mentioning Maricopa, and I worked with Maricopa on their policies. I've also rewritten policies with 2 other colleges here in the state. And what Board Policy 125 to me is saying is you're taking authority away. It's being recommended that you take authority away from the chancellor. I think that's a very dangerous thing to do in the middle of a chancellor search. Vice Chair McLean earlier suggested a broader conversation about this particular policy before you move forward. I couldn't agree more. And I say that based on experience of 3 years working with every single board in the state. And I say that based on a lot of years of being an administrator at colleges and universities in 7 different states. I would caution you to move on this. I would also say to you, the other thing that strikes me about this entire conversation is the mixture between board policy and administrative policy and procedure. So with all due respect to all of you, and I know you all fairly well, board policy is your job. No offense to anybody in the room. It's your job to create board policy. You can have all the input from 1,000 people if you want. You have 4 jobs. Manage, you're a leader, write and manage board policy, approve the budget, and create and approve the strategic plan. Those are your jobs. When you have employees writing board policy, no matter how good they are, and I know somebody in the room isn't going to like what I'm saying, and I apologize for that, but my role is to deal with boards. Your job is to write and deal with policy. This policy, however it ends up, is fine. It's because you're the board. I get to go home at night. You get to be the board, whether it's night or day. So you have to be comfortable that the policy that you create is what's best for Pima Community College. I'm suggesting to you that a conversation about the role of meet and confer or shared governance and what that means to this institution and how you move that forward in light of this is something that needs to happen. Now, I could say a lot more, but this is a public meeting, so I'm going to hold some of those thoughts that I have. I've been watching this board for a long time. I lived in Tucson for a long time before I moved to Flagstaff. I have a sense of what's gone on. I have a sense of the reaction of what's happening now. I would advise you, your decision, I would suggest to you, as my wife said I should say, I would suggest to you that you move slowly on this particular policy, especially because of the effects that it could have long-term for you as you search for a new chancellor. I'm happy to answer questions or take thoughts.
Okay, so thank you for coming, and thank you for the information you provide us. The other thing is, if the board is willing to look at this policy and would approve these changes, if we would not be the ones making the decision, we would just have input, am I correct? And then the chancellor would be the one to make the final decision?
It depends which version you choose, but if you choose the management version, yes. But the reality is, you're going to hire somebody to be the chancellor of this institution. And you have to believe that that person is going to take these policies and manage them the way you want. And if he or she doesn't, then you're managing, the 5 of you are managing him or her. But But when you start managing the institution rather than the leader managing the institution, then you've got 6 different people managing an institution. Does that make sense?
Well, I would say, though, that I think it's important that we hear, that we understand what's going on, okay?
Absolutely.
There's been some issues that we need to address, definitely. But I also believe that the board has to have input. Not so much manage it, but have input. And I believe in the past that these kind of issues would come to the board. Now, I'm not sure on the HLC criteria how that would affect anything, because we're not running the business. We're not managing it. We're just hearing and then making recommendations. The chancellor works for us, for the board. So
I would suggest to you that you don't write a policy, and someone said this pretty well a couple minutes ago. You don't write a policy based on what happened. You write a policy based on what you want to have happen. So whether you like what happened over the last 10 years or not doesn't necessarily matter. It matters in the sense that you know maybe where you have to correct things, but you want to write a policy based on what you need, not based on what happened in the past. And some of the information that I read looks like some of it was written based on what happened, not what is good practice or practice as good as it could be.
and sometimes of what continues to happen.
But then that becomes your job to manage that. My opinion.
Thank you.
I have questions, but not necessarily for David, so I don't mean to keep you up there necessarily as having to represent, having to represent everyone. But do you mind, actually, could you scroll back to the slide that has the two versions on it, that just to have it up there? And while they're doing that, my first question is actually for Chancellor Duran-Cerda. I'm assuming this is true, but I wanted to make sure my assumption was correct, that in this, that what Aubrey presented was also the version that you think that we should be implementing, or have you not been involved in how this has gone forward?
I haven't really been involved in the conversations, but I'm seeing this and hearing it from our colleagues right now. My concern is the HLC, is how they would perceive day-to-day operations, and if they think that the employee handbook is day-to-day operations, and should or should not the board be involved. And I don't know, Wendy, if you have anything to add, but maybe if we do take time to think about this, I can reach out to our liaison in HLC, Linnea Stinson, and see what her thoughts are too.
Yeah, and it doesn't have to be right this moment, but I would be very interested to know what your opinion is, and in your role as interim chancellor, in terms of what the best way that this policy could go forward. So the other issue, which is more, you're welcome to weigh in if you want, but it was more directed over here, was around. I was trying to figure out exactly how to phrase this. So I'm curious about, like, the entire scope of the things that fall under here, and what is a policy and what isn't, because you brought up the issue in there about whether is the handbook a policy or not, and at least I heard one of you say that you didn't think it was, and so in that, I'm wondering, and sorry, this is stream of consciousness, but in terms of, like, also making sure the HLC, if there was a way to draw a really clear line, and I'm just hypothetically, if that line was like, look, everything in the handbook is day-to-day operations, that's the purview of the chancellor, and then the policies are really what the board is governing, and so if we have disputes around policies, that where the board would adjudicate those disputes, that makes sense to me in terms of what our role would be, and have a bright line. But that only makes sense if you can actually draw that line, and if the handbook is sort of commingled things that are policies but not, and other things that are day-to-day operations, I don't know if you can really cleanly draw that line. So I'd be curious to hear from both of you where do you feel like that line is, and or is it possible to draw it?
All right, so we might both give a shot at that. So there's a lot of stuff in our employee handbook, and some of it's broad, big stroke things, and some of it's very specific. Credit hours and how contracts are developed, and days of accountability and holidays and all these different things, all the way to name badges. And so, it's almost like when I hear what you're saying, it's kind of what types of policies, and is there a line at which we have them distinguished from one another? And I think the quick answer is no. When you look at, if you look on the website under the employee handbook, you're going to see a massive array of different things that they guide the operations of our college. And some of those, again, are very broad, and some of those are more specific. So, Michaela's.
So, yeah, I've got a perfect answer. I know all, no, just kidding. We have several different levels of policy, and I think that's partly what the confusion is. So we have board policy, which tends to be extremely broad. You're not going to actually probably be able to implement anything, and you don't know how that impacts your job necessarily. It's more like, this is a federal regulation that you must follow, or this is a statement of our goal and our values. Then we have administrative procedure that has a similar review process to board policy, where it's more detailed in who may be in charge of things and how that might work within the college, that is more information items to you. Then we have standard operating procedures that detail the APs a little bit further, and those are not policy. But if they impact a lot of people, we try to do stakeholder work. Then we have the employee handbooks. They used to be board policy. The whole handbook used to be board policy. They are no longer board policy. When we took all of the different handbooks for the groups and we made one policy, there was a pretty strong effort to separate out procedure from policy. The problem is, by doing that, we created confusion in some places, and so some of those procedural type things have gone back in order to create a policy that could actually be implemented and followed. I mean, we mentioned holidays and recesses a lot. Scott Stewart, if you're listening, hi. You know we love this one. But that one impacts our employee calendar. It impacts how you pay people. We just had to revise it again because there was potential to be overpaying people over winter break because of how things were classified, which are serious financial considerations for the college and for the employees. So are those policy or those procedure? And that's the question. So everything that we have within our employee handbook, it's big picture application to the system, not individual person's role, which I would consider to be policy. But it's not at the same level as the board policy that you approve on a regular basis, if that helps. And then we have departmental procedures that don't go to anybody. So there's a whole nother level.
No, but go ahead, Jeff.
Can I take a stab at this? So under the current definitions, a handbook is not a policy. Right, we have a hierarchy. Under the current, we have a definition. It probably could be clarified or enhanced, but under the current hierarchy, APs and handbooks are not. Policy with a capital P, and one of the things that's confusing is people use policy in a lot of different contexts, right? But right now, I mean board policy, capital P. So, but let me just give you a really simplistic distinction between them, and it's definitely not perfect. Board policies are really about the what the college is supposed to be achieving. It's the big picture. What's the goal the college is striving to meet, or some minimum standard you have to meet? Don't discriminate. That's a minimum standard, right? So most board policies, in a very simplistic way, are one of the, I would say, as a board governance model, fit one of those two. It's the what we're supposed to achieve, or it's some bare minimum standard we have to meet. The how we do it, the how, the who, the timing and all that, that's implementation. That's a procedure, not a board policy, right? Who, other than the chancellor, you don't delegate to other people, right? So who's responsible? That's a management decision. That's the how it gets done. All those implementation descriptions are what I'd say are below a board policy. So the board sets the high level goal or a minimum standard the chancellor has to meet. The chancellor and the rest of the college have to figure out how to get it done. And those are the decisions that ultimately, in typical board governance model, the CEO is ultimately responsible for that. If the CEO is not achieving those goals or doing things that are improper, then it's an issue between the board and the CEO of your performance is not right, or we have to change your goals, or there's something we address, but it's with the CEO, not by changing a college document.
So in this context, when that says when an agreement cannot be reached, multiple policy, when it says policy, is that talking about policy capital P like you just said, or is it that more generic reference to policy?
That's a lowercase.
Yeah, so I think this is meaning this is P in the broadest sense, the little p, not big board policy like I just described it.
One of your feedback pieces might be to change that word if it's confusing to you as we go forward.
I'm just wondering, genuinely, I'm wondering out loud at this point that the way to thread this needle might be to be really clear on what this applies to, and that commingling of things that happened across all of that stuff maybe needs to be unwound, and so that you can draw a really clear line, and then that would help get through what this issue is. Because if we were, like I said, wherever we draw that line, if there was something to drop below that really needed to be a policy, maybe it needs to be pulled out of whatever it is and elevated to that point, so that you do make a really clear distinction between day-to-day operations and what policy actually is. I don't have an exact solution for how to do that, but I for some reason, when we've had this discussion, my gut says that's the issue, that it's all been commingled and it needs to be unwound or untied together in a way that is logical, so that you can draw a line and say, this is policy, this is day-to-day operations, in a really clear way. And then we can demonstrate that to the HLC. But then disputes like what you're talking about policies could be appropriately brought to the board, but it wouldn't bring to the board the things that are really disputes about day-to-day operations. I know definitions are not the sexiest thing to talk about, but I really feel like that definition is this entire issue that's going on right here.
So I would suggest that before you define policy, then you actually need to define day-to-day operations, because that's really what the issue is what is a day-to-day operation. And if you can define that, then we could clarify the policy portion.
No, thank you.
Yeah.
Maybe that's what Wade meant when he was talking about earlier about it. Maybe I've just kind of backed my way into what you were talking about anyway. But that's helpful. Thank you.
So one of you just said definition. So the definition of to delegate, according to Google search, it said to authorize a person to represent us, right? So basically, when we're delegating the chancellor and her appointee to do something, to me, it seems as if it is one of our responsibilities to make sure it's happening. So I'm feeling like just because 1.05, we're delegating the chancellor, that's because, maybe we don't want to be involved in all of those decisions. But what we have to understand here is if we believe in collaborative, I just had a blank, shared governance, thank you, and collaboration. And if we believe in equity, we used to call ourselves an equity institution and all of those things. It seems to me that I still haven't heard a reason for me to be okay with making this the chancellor's responsibility, right? The fact that there are many, many institutions that the HLC reauthorizes their accreditation all the time, and they're not in jeopardy. So I think that the threat, I don't want to weaponize our HLC accreditation, right? I think that, to me, that's just off the books, because if we're governing and doing what we're supposed to do, on that one statute I always talk about, number 7, determine the salaries of the person it appoints and employs. And then right before that, it's appoint and employ a chancellor, vice chancellors, presidents, vice presidents, deans, professors, instructor. It goes all the way down to the grounds crew, right? So I think that what the state statutes say that we're supposed to be doing, also visit each community college under its jurisdiction and examine carefully into its management conditions and needs. Well, the management conditions and needs, that is what these employee handbooks or end up being. So until someone can give me some reason that it is better for the chancellor to decide if you all can't come to consensus, then the board that is elected to do all these responsibilities, I'm just not convinced yet. So, definitely keep the communication going, but I don't feel. I did speak with David Borofsky today, and he mentioned one thing that made me think, maybe I better think this through a little bit more. He said, there's a good chance that a chancellor might not want to come to a place, I'm paraphrasing, but then a little while later he said, this is the most amazing institution in the United States in so many ways, right? We're not going to have a problem not having great candidates wanting to come here, whether we do this board policy one way or the other. That's not going to keep somebody from wanting to work at this college. So anyway, thank you. Any other comments?
I guess just going back to my timeline. So what is the timeline? I hate to, so I know maybe we need to have this other larger, more strategic discussion about what is day-to-day operations, what is policy, where do we want the board to happen. I don't want us to lose sight of that happening in a timely manner, so that all the work that's been done since January, forget when you introduced that first one,
February.
I don't want them to feel like they've done all this work and then it just sort of fizzled into us having to get our butts in gear. So yeah.
Well, it is on our agenda for Wednesday, and so is it not?
So BP 1.25 is not on the agenda, but we could add it to the agenda if you want to talk about next steps. The ones that are on the agenda right now are the no revision or minor revision. Those are on the consent agenda for approval. We anticipated that we might need more discussion about BP 1.25, so it's not on the agenda at this point for action or anything. But like I said, if you want to talk about some next steps, we could certainly modify the agenda to create a chance to do that. And the question is, do you want to do that Wednesday at a regular board meeting, or do you think sometimes regular board meetings are not the most conducive to discussion, and maybe it's a study session, or maybe it's both? Maybe at the Wednesday meeting you talk about next steps and then we decide what else needs to be scheduled.
So real quick, on that fourth slide in that presentation, it had the process overview. Board member proposed revision was number 1, AERC resolution, team working on it. 3 shared governance groups have talked about it. And now we are on the board study session. For the ones that have no comment or no change and little change, where step 5, 6 just skipped because there was no, okay.
So getting back to timeline then, we could add something. I don't mind having whatever that larger discussion is during the board meeting. Unless we don't have to. We can do it whenever you all feel like, but and this is a very honest statement. Whether or not I agree with whatever the majority of this group decides or not, I genuinely am more concerned just about making sure it doesn't just sit. We have to actually make a decision and move something forward, whatever the majority of the board agrees on. And so I don't want it to just collect dust somewhere, and everybody that's put all this work in is like, well, what did I do that for? It just sat on their table forever. So I don't know. I genuinely don't know exactly what that looks like. If we could at least start that on the board meeting, I think that would be good. But we're going to hit holiday break before too long here, and then then we're back into the early part of the year where we've got budget and all these other things. So I'm sort of feeling like it's a it's kind of a now or never, but I don't mean literally right now, but it's going to get lost in a lot of other stuff if we don't move something forward.
Yeah, let's add it. to Wednesdays. Okay, great. Okay, now is there a motion to move to exec session? And a second?
Second.
All in favor? Aye. Passes unanimously. So thank you, everybody, for being here. We will not reconvene, so we'll see you on Wednesday. Get lots of good sleep between now and then.